Hi everyone, we are Katie and Emily and we are the joint heads of legal advice at Working Families. We're both employment solicitors and we're both mothers of 4 children. We're very used to balancing our work and our caring responsibilities. So we're here to talk about flexible working, how to apply for it, how to negotiate it, what you do if your request is refused, and then the next steps that you take after that. We'll be sharing some slides, so I'll be bringing those up, hopefully, if the tech gods are on my side, and be handing over to Katie in a moment, who'll be talking, first of all, about what is flexible working.
Thank you. Thanks, Emily. So what is flexible working? Flexible working basically means changing your workplace conditions relating to the hours that you work, the times that you work, and the place where you work, so that you can work in a more flexible way. There are many different ways to work flexibly, so including part-time working, changing your hours, compressing your hours, a job share or job split, like Emily and me, term time working, annualized hours, or working from another location. Or in fact, a mix of any or all of those even. There are numerous types of ways to work flexibly, but the important thing is to find a solution that can work for both you and your employer. You can ask to change your working arrangements for any reason or no reason at all. The most common reason that we deal with at Working Families is for caring reasons, and especially caring for children. So next slide is who can make a request. Firstly, anyone can make a request to work flexibly at any time, and that's really important to mention. However, certain individuals have the right to make a statutory flexible working request. When you make a statutory flexible working request, which is essentially a request made under the law on flexible working requests, there's a process set out in law that you and your employer need to follow, and there are certain claims that you may have if your employer fails to follow the correct procedure or dismisses you or treats you unfairly as a result of making the request. So in order to make a statutory flexible working request, you have to be an employee. Although you no longer have to have 26 weeks service before you can make a statutory flexible working request, you do unfortunately still have to be an employee. Now, there's a difference between an employee and a worker, and it can sometimes be difficult to know which category applies to you. So if you're unsure, or if your employer says you're a worker but you think you're an employee, then we recommend that you seek legal advice or check our web pages for further guidance on this. We have quite a few pages looking at the distinctions. The other thing is you can't have made more than 2 statutory flexible working requests in the last 12 months. This used to be 1. And finally, you can't have an ongoing flexible request which is yet to be determined. So as we have said, even if you're unable to make a statutory request, anyone can make a non-statutory request at any time. An important thing to mention here is whether or not you're making a statutory request or a non-statutory flexible working request. If you're making the request due to childcare or other caring responsibilities, your strongest arguments and protections are likely to come from the Equality Act, which apply irrespective of whether or not you've made a statutory request. And we're going to talk a lot more about this later. So back to Emily on how do you go about making a flexible working request?
On mute. Thanks, Katie. So as a first step, we generally suggest you speak to your employer about your intention to make a statutory flexible working request before actually putting in the formal request, if this is possible, because by speaking to your employer rather than just sending a formal letter, you bring that human element to your request, which is never a bad thing. And many employers feel less threatened when approached in this way and may well just be inclined to agree. Also, you then get that better understanding of your employer's mindset in advance, which can help you to address their concerns and put together a stronger application. So following that informal discussion, you then submit your formal statutory working request. And you do this even if you've reached an agreement in principle with your employer, so that you get that extra protection in law relating to these requests. So there are formalities on how you do it, which are on the slide and also detailed on our website. And we've got a template letter you can use as a basis. Your request must be in writing. It must state that you're making a statutory flexible working request and include what's on the slide, the date you're sending it, the change you'd like to make, when you'd like the change to start, and the date of any previous requests. The law changed in April, and it's no longer a necessity to explain how the proposed change would affect your employer and colleagues and how that might be dealt with. This was removed because of the onus it put on the employee, particularly if you've only just joined, you may not be aware of the impact on your employer's business. However, because flexible working requests are essentially a negotiation, we do recommend you consider the impact and include rationale wherever possible in your application to show how you think it will work in practice, as it could help to show how it will work in the business. A good starting point is to look at the business reasons employers often rely on to refuse a request, which we will come to later. And Katie will be going into negotiating tips to consider. And generally, we suggest you put yourself in your employer's shoes, think about any concerns and try and address them. Focus as much as you can on the positives, explain how you'll be engaged and more productive if you're given this flexibility, and how it will support you as a parent and carer. It really could be win-win for both of you. And even though it's not a legal requirement, it is a suggestion in the ACAS code, and something we always recommend is that if the reason your flexible working request is being made, it relates to your childcare, caring responsibilities, or a disability of yours or someone that you care for, then make sure you explain that you understand the Equality Act is likely to apply, and put this in your written request. This does a couple of things. It helps alert your employer that it could be discriminatory to refuse your request, and hopefully will very much frame the discussion going forwards. It's a good idea to set out what the impact will be on you if you can't work flexibly, particularly if you're going to struggle to continue to work because of your childcare difficulties, as an important element of a discrimination claim is showing the negative impact on you of refusing your flexibility. Katie mentioned non-statutory requests. We would suggest doing a very similar thing, putting it in writing, and you'd pretty much include everything other than saying it's a statutory request. Finally, in terms of timing, your employer can take up to 2 months to respond to a statutory request with their final decision, including the outcome of any appeal. So it's important to get this request in early. Often when you're returning from maternity leave, you'll need to have got in touch with nurseries and childcare providers quite early. So if you know what dates are limited to, or what days, then do get in touch and put that application in so you've got good time to negotiate with your employer. And now I'll be handing over to Katie on what the obligations are once you have made that flexible working request. So what must your employer do?
Thank you, Emily. So in relation to statutory requests, employers have the following obligations, which are in addition to any discrimination protections you may have under the Equality Act. So these additional obligations are that they must deal with your request in a reasonable manner, and I'll come on to this later. They have 2 months, as Emily said, to give you a final decision. They can only refuse a request for one or more permitted reasons, which again, we'll come on to later. And as of the 6th of April 2024, they must not reject your request without first consulting you. This means that unless an employer decides to agree to your flexible working request in full, so exactly what you've asked for, they must consult with you before they make a decision. So what does dealing with the request in a reasonable manner look like? Unfortunately, there's no statutory definition for this, but there is ACAS guidance and an ACAS code, which have recently been updated and which make recommendations on how an employer should deal with a flexible working request. In particular, the ACAS code makes various recommendations that an employer should follow. So, for example, they need to carefully assess the effect of the requested change for both you and them, such as potential benefits or other impacts of accepting or rejecting the request. They should arrange a consultation meeting without unreasonable delay if they do not agree to the request in full. If the original request cannot be accepted in full, they should discuss whether a modified version of the request might work instead. And another one is if your employer allows appeals, the appeal should be dealt with as quickly as possible. Now, as I've said, those are just a few of many suggestions made in the ACAS guidance. It's quite a long document. And whilst there's nothing unlawful if your employer fails to follow the code uses the word should for things that are recommended but not legally required. An employment tribunal must take the code into account when it appears relevant when dealing with complaints relating to statutory requests. So we've included a link to both the guidance and the code in the slides, and recommend that you read these before you make a flexible working application. And you may also want to refer your employer to both the code and the guidance too. It's also worth checking to see if your employer has its own flexible working policy, as it may well be more helpful or generous than the statutory scheme, and your employer should follow one if one exists. So now in relation to meetings, there's still no legal requirement for your employer to invite you to a meeting, but as I've said, your employer must consult with you if they're not going to agree to your request in full, and the ACAS code states that this should be done in a meeting. If your employer does invite you to a meeting, there's no requirement for this to be face-to-face necessarily, but it must be held privately, so on the phone would be okay, and you should be given prior notice of the meeting. The code also states that you should be allowed to be accompanied to a meeting by a fellow worker or trade union representative if the request is a reasonable one. And if you cannot attend a meeting, your employer should rearrange it if you fail to attend two meetings. And if you fail to attend two meetings, then the employer can take your request to be withdrawn, although they have an obligation to find out the reasons for your non-attendance first and consider your reasons. So next slide is how should you prepare for a flexible working negotiation? So as we've said, if an employer is minded to reject a flexible working request, the new code puts much more emphasis on the importance of considering whether a modified version of the request or any other alternative options might work instead. And employers are expected to propose compromises where possible, rather than just rejecting a request outright. There's therefore much more scope to negotiate with your employer, and the following tips might be helpful with your negotiations. So firstly, always plan ahead. Plan what you're going to say, including how you will answer any questions which might come up. Think about your employer's perspective in advance. As we've said, although this is no longer a requirement to include this information in your request, it can still be really helpful to consider, if possible, why your employer might say no, and be ready to provide suggestions for how their concerns could be mitigated. Is there someone else who can cover the office phone for half an hour at the end of the day, for example, if that's the issue? Don't expect to get everything you've asked for necessarily, so make sure your plan includes what you will do if you don't get an absolute yes, including any options that could also work for you. So for example, if you need to leave work early to collect your child, alternatives to working part-time could be working different hours, or starting or leaving early, or working from home on certain days. If your employer has concerns about you working part-time and the impact that this will have on availability for clients, you could perhaps suggest a job share. Don't offer something that doesn't work for you though. So if you're not sure about something that your employer proposes, it may be best to say that you need to think about it before agreeing to the suggestion. The next thing is it's worth gathering information on colleagues who work flexibly or have made flexible working requests. So do you have any colleagues who've made a flexible working request? If so, ask them about the request and what made it successful or unsuccessful. Do you have any colleagues who currently work flexibly and it's working well for them? You can use this as an example when you speak to your employer. Give your employer as much information as possible. And as we've said a number of times, make it very clear if your request is because of childcare, caring, or a disability. So, for example, if you're a single parent, have no other support, let your employer know this. Explain to your employer what the impact of refusing your request will be on you. So, i.e., will you no longer be able to continue working? It's generally never a bad thing to appeal to their human side. Always negotiate in a positive and solutions-focused manner. Explain how this can work for both you and your employer. So, for example, many employers report productivity gains, improved retention, improved diversity and inclusion when they embrace flexible working. Remind your employer how much you love your job, if appropriate, how long you've been employed by them, and that you don't want to leave your job. Also consider whether or not your request is just for the short term, perhaps because of temporary childcare issues. If so, you should make this clear, as changes are permanent unless otherwise agreed. Always be aware that a reduction in hours will result in a pro rata reduced pay, benefits and paid leave. So, and if your income will reduce, our benefits advisors can support you with more information on maximising your family income with in-work benefits. So have a look at our website and contact details. If you are moving to reduce hours and pay, your workload should also reduce, and sadly this often doesn't happen. So it is really important to raise the issue of job design in your meeting. Now, if despite your best efforts, your employer isn't initially keen, then do suggest a trial period. So for example, 3 months with an agreement as to what will happen if there haven't been any reasonable objections. Will it become a permanent change? It can be really difficult for an employer to refuse a trial period without looking unreasonable. And finally, keep notes. Try to make a note of all conversations about flexible working if possible. This is important in case your employer tries to change their mind or refuses your request and you would like to challenge their refusal. An effective way to do this is to send an email to yourself at the time, and then you'll also have a timestamp. I'm going to pass back to Emily now for what can you do if your flexible working request has been refused, and what claims can you bring?
Thanks, Katie. So the flexible working rules fall into kind of two areas, as we talked about. There's the flexible working legislation, which talks about the process that should have been followed. And then there's the Equality Act, which provides this kind of overarching protection from discrimination. So the flexible working rules recognise that there may well be legitimate business reasons for a flexible working request to be turned down. And there's the 8 reasons listed on this slide. They are pretty broad, and as you can see, any employer will probably be able to rely on one or more of these reasons without looking into too much detail when rejecting an application just under the regulations. However, the ACAS code suggests that when refusing a request, the employer should set out additional information that's reasonable to help explain their decision. And that would include steps your employer took to investigate whether it could accept your request, alternative options they considered, and the data they used when making a decision, such as staffing levels and recruitment costs. So the flexible working regulations allow for these reasons of refusal. However, even if they've used one of these reasons, the refusal could still be a form of discrimination, and you'll have that protection from discrimination, which Katie will come on to. So you're not in, you can still potentially challenge it even if they've used one of these reasons. And the first step to practically deal with a refusal is to consider making an appeal. There's no legal kind of right to appeal, and there's no process set out. But again, the ACAS code suggests that allowing appeals is good practice. And so it would be helpful to show that your employer's dealt with your request in a reasonable manner. And it may well be part of your employer's flexible working policy, so check that out. In any event, we would still suggest you write to your employer to appeal their decision, and we've got a detailed appeal letter on the website. This allows you to put forward your arguments again, to suggest alternatives that you may have looked into that could work since your flexible working consultation, and also to address any concerns that your employer has raised with you. It also flags that you know your rights and can be a nudge for many employers to go on and agree your request. In this appeal, if it's not been asked for already, to suggest that trial period and to counter and challenge any reasons they gave for their refusal. So if they've said there'll be increased recruitment costs, what would happen if they turn down your request? Are they going to have to recruit in any event? And so there isn't an actual additional loss there. But if they go ahead and stick to your refusal and you do need to take things further, the fact that you've appealed demonstrates you've given them every chance to discuss and negotiate with you. So who do you appeal to? If it's not in your employer's policy, it's generally best for someone more senior and independent to decide an appeal who has the authority to overturn the original decision. The appeal and any outcome should be dealt with within the 2-month time frame unless you've agreed an extension. So what happens next if you haven't been able to agree your flexible working request through the appeal process? Well, we'd suggest that you take advice probably at this stage, and that's because not every request will succeed, and sometimes the refusal will be reasonable, and the next steps very much start to escalate the situation and can result in an acrimonious situation that makes continued employment quite difficult. And it's, in our view, only worth doing where you really have suffered some discrimination, you can no longer work, or if, say, you've been dismissed. I'm not going to go into loads of detail because there's lots of information on our website, but the next step would be to raise a grievance, which means putting your complaint in writing. Again, we've got template letters on our website. And it's important to do that because it can impact any compensation awarded by the tribunal if you fail to do so. And then as a final step and very much a last resort would be to consider bringing a claim in the Employment Tribunal. Again, take on advice on what those claims would be if you've got any and what your losses are. But bear in mind there are strict time limits, which are 3 months less a day of the act complained of, and this is likely to run from the date of the refusal of your request, or possibly even earlier if there's been an earlier act of discrimination. So put that date in your diary, and that time limit doesn't change even if there's an ongoing appeal or grievance procedure. So it's really important to remember that. If you're still in the process of dealing with an appeal, then contact ACAS to conciliate so as to preserve the time limit in your claim. If your grievance doesn't resolve the situation, the next step would be to contact ACAS to conciliate and then to bring a claim. And again, this is all within the 3-month time limits. There's lots of information on our website about how to contact ACAS, what the Employment Tribunal process is, with pages and pages of documents if you were to take it further. So I'm going to hand back over to Katie because we've talked about the process that you follow, and then this is to give a bit more of an explainer about the additional protections under the Equality Act where a refusal might be discriminatory.
Thank you.
Oh, skipping on, sorry. Next slide again.
Thank you. So I'm going to focus on indirect sex discrimination, as this is something we advise on often and is particularly relevant if you make a flex request for childcare or caring responsibilities. So indirect sex discrimination happens when an employer has a particular policy or way of working that applies in the same way to both sexes, but puts you at a disadvantage because of your sex. So, for example, if you're a woman and your employer has a policy requiring everyone to work full-time hours, you may have a claim for indirect sex discrimination. This is because a lot more women tend to have caring responsibilities for children or dependent adults, and insisting on full-time hours is likely to disadvantage women disproportionately. Another example could be if your employer insists on 100% office attendance. Again, this practice is likely to disadvantage women disproportionately due to their childcare or caring responsibilities, and again could form the basis of an indirect sex discrimination claim. And in fact, Working Families intervened in a case which has now confirmed the principle that employment tribunals need to take as given that women tend to have more childcare responsibilities than men. This is known as the childcare disparity. So you won't need to establish this if you were to bring a claim. That would just be taken as fact. However, an employer can successfully defend an indirect sex discrimination claim if they are able to show that there is a good reason for the policy or way of working. So, for example, the requirement of full-time work, and that it was proportionate. This is known as objective justification, and it's often the battleground for indirect sex discrimination claims. So in order to look at this or assess this, the tribunal will examine the aim of the employer's policy or way of working and consider how essential it is for the business, and then weigh this up against any discriminatory effects against you. When deciding whether indirect discrimination has taken place, tribunals look at the individual circumstances of each case, and what might be a justified policy in one set of circumstances may not be justified in another. A key point is that if there is a less discriminatory way of achieving the aim, it will be more difficult for an employer to justify the policy. Now, some general principles have been developed by the courts over time in flexible working cases. And these are that the employer must show that they have thoroughly examined whether the change you have requested is feasible and what problems insisting on full-time work, for example, will cause you compared to how essential it is for the business. Generally, added costs will not be a good reason if this is the only reason for rejecting the change. This is why it really is important that you explain to your employer what the impact will be on you if your request is refused. Your employer must have considered the alternative work pattern you suggested and possibly any others that might help you, and not just dismiss your request without really thinking about it. And finally, we hear about this a lot. Your employer must not have relied on generalizations or assumptions for rejecting your proposal. So, for instance, if your employer has a blanket policy against flexible working because of fairness to all, or the assumption that flexible working is less efficient, or they don't want to set a precedent, this is quite likely to be discriminatory. As we've already mentioned, there isn't much scope for a tribunal to examine the commercial rationale of an employer when a claim is made under the flexible working regulations, whereas with an indirect sex discrimination claim, the reason why the decision has been reached will be fundamental to the outcome of the case. And there is much more scope for the tribunal to really scrutinise your employer's decision. So we've talked about women being able to make indirect sex discrimination claims. What about men who have their flexible working requests refused? Previously, men have only been able to claim discrimination in relation to flexible working refusal if they could demonstrate that their request had been refused simply because they're a man. So this would be the case if an employer routinely agreed flexible working requests for women, but refused a man's request because of his sex. And this would amount to direct sex discrimination. Up until recently, men have been unable to bring an indirect sex discrimination claim in relation to flexible working requests, as these claims have generally required the individual making the claim to also belong to the disadvantaged group, so women. However, recent changes to the Equality Act have now introduced the concept of same disadvantage, which effectively means that an individual can now potentially make a claim for indirect sex discrimination if they can show that there is a group disadvantage. And although they may not belong to the protected group, so women again, they nevertheless suffer substantially the same disadvantage as the protected group. So a man with childcare responsibilities who has been refused part-time work could now potentially make an indirect sex discrimination claim based on the fact that the requirement to work full-time disadvantages women with childcare responsibilities, and that he suffers the same disadvantage due to his own caring responsibilities. It is important to state that this is a new law, came in January this year. It is as yet untested in the ET, but the amendments to the Equality Act mean that such a claim is now theoretically possible, and it's certainly worth the argument to an employer. So it's back to Emily now on complaints and remedies available under the law.
Okay, so thanks, Katie. We've talked about the steps you take to assert your rights, but what you need to understand is what potential claims you would have and what you could then recover in the tribunal if you then decided to take it further. So kind of going from low to high under the flexible working rules, if you could bring a claim if your employer gave a reason which isn't one of the 8 permitted reasons or was based on incorrect facts, if they failed to deal with your request within 2 months or in a reasonable manner. But the tribunal's role is really pretty limited under the flexible working rules. It's more about the process, and it kind of lacks the teeth of some of the other claims that we've talked about. In addition, the tribunal will not order your employer to change your terms and to require them to allow the flexible working that you've requested. They may order them to reconsider your application, so you could end up in a loop where you just keep asking and it getting refused. If your employer were found to have breached the kind of statutory flexible working, then your claim would be for compensation capped at a maximum of 8 weeks capped pay, which is currently around £700 a week. And they will award just a 1 week pay for fairly administrative breaches. So we rarely tend to see claims along the flexible working for breach of flexible working regs alone. And that's why we've talked a lot about the Equality Act. And it's also important to bear in mind that going through a tribunal process is stressful. It can damage your relationship, and it's really something that you should only consider if you're going to get something out of it that's worthwhile. So the kind of bigger claims would be if you've been dismissed because you've obviously made a flexible working request, or because you've said that you're planning to make one. Then you'd have a claim potentially for automatic unfair dismissal. And with that, automatic part means you don't need the 2 years qualifying service to bring the claim. Your compensation that you'd be going for would be for your loss of earnings, and that's capped at the lesser of 1 year's pay, or £115,000 if you're lucky enough to earn that much. There is another claim for unlawful detriment. If you've been subjected to a detriment, say you've had a bonus removed or been treated unfavourably because of requesting flexible working, then you'd have a standalone claim for that. And then the kind of biggest claim that we've talked about, and the one that probably strikes the biggest fear into employers, is discrimination claim. If there's been a discrimination handling or the refusal of your request. Even if your employer has followed the administrative process to the letter and has relied on a legitimate business reason in refusing it, you could succeed in a claim for discrimination. And the reason that that's a fearful claim for your employer is compensation in discrimination claims is for uncapped loss of earnings based on what your earnings would have been and what your actual losses are. You have to mitigate, which means you have to try and find another way of replacing your earnings if you've left employment. So you'll need to show that you've looked for another job, but that's what your claim would be. And you'd also be given an award for an injury to your feelings. There's lots more information on how to calculate damages and loss in the Employment Tribunal on our website. One other area that we haven't talked about that is important to be aware of is the rules around part-time workers. So if you've managed to get your request approved and you've become a part-time worker, you're entitled to be treated not less favourably than other workers as a result of your part-time worker status. So you shouldn't be discriminated against or subjected to detrimental treatment. So it's just something to make sure that when you are getting your terms and conditions put into a new contract, that you have got a pro rata entitlement holiday, to bonus, or any commitment formally a part of. And that there's more guidance on our website around part-time workers' rights. So I think that that's everything. I'm going to stop sharing that we've whistled and rattled through on flexible working. There are so many pages on our website. There's template letters, as we've said, for requests, appeals, grievances, templates for bringing claims in the tribunal. Anything else, Katie?
I think that's everything.
But do get in touch. Yeah, get in touch via the website or our helpline if you need further advice. But thanks for listening.